to reiterate just the topics, and I'm trying not to get it too lengthy, but leave plenty of time for discussion. But to reiterate, we discussed that al-Hakimiyya is part of the discussion of Iman and Kufr. And that whoever believes in or sets up laws to govern other than the laws of Allah subhanahu wa ta'ala is a kafir, is not a Muslim. And that a person who acknowledges the Shari'ah, in other words, the state, everything is set up according to Islamic law, but in some aspects overlooks Islamic law, is a major sinner, a kafir of a lesser degree, but is still a Muslim. Because many actions are called kufr in the Quran or in the Sunnah, such as fighting other Muslims, killing Muslims, or that the sinner, like the zani, the adulterer, when he commits zina, his iman leaves him and is up above him, overshadows him. So these are examples of actions that you could commit which are called kufr, but you are still considered a Muslim legally in Islam. But if you set up laws besides the laws of Islam as the laws of your country, and you say that this is legitimate and that you have no obligation to set up the laws of Islam, then you are kafir outside of the ummah of Muhammad sallallahu alayhi wasallam. So al-Hakimiyya, or this concept of ruling by Islamic law, is an essential part of Iman. And we discussed advice, having goodwill towards the Muslims, rulers and common folk alike. And that this is part of the deen, and that the deen is not complete without the concept of nasiha. And this is to be done always with wisdom and in the best way. It is never the intention of the Muslim to create conflict, hatred, enmity, fitna among the Muslims. And therefore, it's essential to use wisdom when we perform the Amr Ma'ruf and Nahi Anil Munkar, commanding right and forbidding wrong. And there are times and places for every type of discussion, for every kind of advice. There are times for public discussion and times for private discussion. And these are matters of wisdom, and they're matters of ijtihad, the ulama have done from time to time. And we've talked about the fact that it is required of a ruler in Islam to set up a council of shura and to seek the advice of the ulama in all matters pertaining to the laws of Islam. And that the ruler who refuses to do this thing is not ruling by the Shari'ah. According to the ulama, it's obligatory for the scholars to be consulted in matters dealing with halal, haram. But the shura goes to other people. For example, the military experts are consulted in military decisions. Economic experts in economic decisions, not considering the Sharia aspects of those things, but common knowledge kind of things which some people are aware of and some people are not. And the common people are consulted considering their masalih, or what is a benefit and their welfare. So people have a right to be consulted concerning anything dealing with the masalih or their welfare. The rulers do not simply impose decisions out of their caprice on the rules, but they consult with the people or representatives of the rule concerning the needs of the people, which are known to the people themselves. And this is something which is not of dispute among anybody. The only thing which is disputed about shura is whether the opinion of the shura is binding on the ruler or not. And there is a different opinion about that, and the correct opinion is, inshallah, that it is binding. But even if it were not binding, that's in the case that the ruler himself was a mujtahid. That is, if the ruler himself is a mujtahid in the religion, if he is capable of making judgments concerning fiqh matters, then he does not have to take the advice according to some opinions. I mean, he has to seek their advice, but he does not have to see it as binding. That is, if he has a better dalil and a better evidence, then he can follow his own way. And this is the only way that you could understand, for example, the fact that the Prophet ﷺ always followed the shura of his Sahaba in the absence of wahi, or revelation from Allah. And that the Sahaba followed the decisions of each other, the Khulafa Rashidun followed the decisions of their shuras. And the Umar ibn Khattab actually made the shura to be the electors for the next Khalifa, and they unanimously elected Uthman ibn Affan as the Khalifa. So, there is not any controversy about the obligation for shura. And this is an essential part of the rule of Islam. The ruler who refuses to practice shura is rejecting the Shari'ah of Allah subhanahu wa ta'ala. This is one of the essential parts of the Shari'ah which is being rejected by the ruler. And this is not acceptable to the ulama, and therefore that kind of ruler is best removed if possible. That can be done without fitna in the society. There are times, and people have discussed, when you speak openly and when you speak privately. And according to Shaykh al-Islam, we distinguish between this. In Nahi an al-Munkar, for example, if forbidding what is haram will cause something worse to happen as a result, then we avoid it. So, if forbidding the evil will create a bigger evil, we choose the lesser of those two evils. So in this case, we avoid Nahi an al-Munkar. But according to Shaykh al-Islam, we must distinguish between that and saying that it's permitted. It's not the same if I'm silent because I don't want to cause bloodshed. That's not the same thing as if I say that, it's all right what is being done. That is that I hate it in my heart, but I fail to speak because by my speaking it's going to cause serious harm to other people, for example. So if there's fear of the consequences, that is a legitimate excuse for not making Nahi an al-Munkar. But if, for example, there's reason to believe that if you speak openly, that the thing will be stopped, the practice will cease, then it becomes your duty to say it openly. And there's another reason for openly speaking out, and that is لِإِقَامَةَ الْحُجَّةِ بِحَسْبِ الْأَحْوَالِ. That is, if circumstances permit, that if you speak out, you will not be obeyed, but no one will be punished for doing so. Then you have established the truth by speaking out. You've established the proof that the people who are committing that practice are violating the law of Allah. In that case, it's permitted to speak out. So if you can't speak out in such a way, then it becomes necessary for you to do so, for the hikmah and wisdom of establishing proof against the people who are committing sins against Allah subhanahu wa ta'ala. Those people of the Sahaba who openly fought the rulers, even though they are considered to have made mistakes and been in error, they are not called Khawarij in the religion of Islam, because they rebelled and fought the rulers based on their understanding or ta'wil. They are not what are called Khawarij Mariqun, who are renegade defectors against the Ummah. They are people who performed ijtihad and made a decision that this was the time to openly rebel against the ruler. And although it's considered mistaken when they did that, they are not in any way considered by any of the ulama of Ahl Sunnah Jama'ah to be the equivalent of the Khawarij who left and rebelled and are one of the detested groups in Islam. So calling a scholar who through his ijtihad has openly rebelled against the ruler, even mistakenly, is wrong. Because he's done so based on an ijtihad, not out of evil intent. But in Ahl Sunnah Jama'ah, we consider it wrong to call the people to fighting the rulers, taking up arms, because that leads to civil unrest in which innocent lives are lost. And the scholars who are being accused of being Khawarij by the ignorant people have never called for any of those things. In fact, they